right, so welcome to the Entrepreneurial Strategy Series. We hold these events every month on topics related to inventorship, on the entrepreneurial journey. We have exciting stuff coming up, but we'll probably talk about that at the end. This topic is an important one because all of you are going to have businesses or already have businesses. All of you will have websites. And all of those websites will need to be protected. Hold on, there's a few more people coming in. And so all of those websites will need to be protected, usually by trademarks. And we're going to talk about what the connection is between a trademark and a domain name and a website. But they also have to be protected, and this is a really hot topic today with what's going on in the Ukraine. They have to be protected from a cybersecurity perspective. Right. And so that's, I mean, Paul, it's like, this is like the perfectly written script for you, what's happening in the world today. Those are the headlines. And so I just wanted to give everybody just a very kind of brief overview of the relationship between domain names and trademarks. It's often misunderstood. Often a client will come into the firm and say, well, I bought the domain name, that means I own the trademark. And it doesn't really work that way. And I kind of want to break it down a little bit. So I have a few slides. I'm not going to go into all of them. I will send them to whoever wants it. You can have it, but just to kind of set the stage for where we are today. 1 second. So back in 1998, right? So the actual domain name system is not or had not been around for that long. So back in 1998, the domain name system was formed, and the company that kind of runs it, if you will, is called ICANN, the Internet Company for Assumed Names and Numbers. It's actually a not-for-profit public benefit corporation led by Esther Dyson, who's actually, still around and a very avid investor in, some of my clients' startups and stuff like that. And so she's very kind of connected still to this kind of digital technology world. But basically, the domain name system was created to support the rights of brand owners. So if you had a trademark, the domain name system was specifically created to help your brand emerge on this new retail space called the internet. And so they wanted to make sure that, and so if you kind of think of it from that way, right, the domain name system was there to support the trademark system, not vice versa. It ends up supporting each other, but that was kind of the origins of it. And so to do that, the domain name system basically created a system by which you can own the corresponding domain name to what your business or product or service was called. That's really why it was set up. So if you were selling a product called Google, then it should go without any doubt that you would also own the .com, or what's called the top level domain name that corresponds to your trademark. That's ideally why it was set up. That's not ideally how it played out, unfortunately. And unfortunately, people saw this as an opportunity. People definitely bought up different domain names that didn't correspond to any sort of business that they were creating. And so when I, as a legitimate business holder, had a trademark and I wanted the corresponding domain name, I wanted that property to sell my good or service, I now had to deal potentially with another entity that already owned the domain name that should have belonged to me. And that concept is what's called potentially, from a 30,000 foot view, it's called cybersquatting. When somebody sits on your domain name that legitimately should belong to you because you own the trademark. And I keep saying that you own the trademark. So this all assumes that you as a business holder will actually file for a United States federal trademark. The domain name system is international, right? So if I'm talking to people in China, then they should be owning the corresponding Chinese trademark to go along with their Chinese domain name. And the same thing to people in Europe, right? So, but right now we're going to just focus on the United States. And so this assumes that you will go through the United States federal trademark process and emerge with a trademark. And to get a trademark, we're not going to go through trademark law per se, but in order to get a trademark, your trademark has to be distinctive. It can't really be what's called generic, right? You've heard that term before. Like if you think about the company like hotels.com. So trademarks are all about owning a piece of property, right? It's your intellectual property. And so the trademark office is there to say to a property owner, an intellectual property owner, that you own that specific piece of property. But in this example of hotels.com, the government is not going to give any one company the right to control the word hotels. That is what's called a generic word. It belongs to everyone. And so, you have to think about, I need to create not only a distinctive trademark that may not be generic, but if I really want the rights to the corresponding domain name, I need to kind of build my case for that as well. And so again, if there are any questions, I can't really see them coming in, but I'll just move on just very quickly. Just to say this last point, which is that when you as a trademark holder actually create a trademark that's not generic and distinctive, and you actually get it awarded to you by the United States Trademark Office, and you believe that, and you also want the ability to get the corresponding domain name, but somebody else may have it, then you can actually go through a procedure that ICANN, right? That was the company that kind of created this entire domain name system. You can actually go through a procedure called the Uniform Dispute Resolution Proceeding and basically request, and this is why we have Adam on the panel. I'll explain who he is in a second. But you can actually basically file a complaint and request ICANN to force the transfer of that domain name that somebody else might have to you as the rightful owner, because you own the corresponding US federal trademark registration. And it's a process. I think it's about 60 or 90 days. It's basically an arbitration proceeding. And Adam Samuel, who you'll hear from shortly, is one of the arbitrators that decides those disputes. And under this UDRP, these types of disputes, there are certain things you have to prove. There's actually 3 prongs that you have to prove. One, you need to have a trademark. I said it before. You need to have a federal trademark registration. That is what kind of gives you the second prong, which is that you have the legitimate right to it, and that the person that currently has the domain name doesn't, right? So you're trying to prove that not only do I have the federal trademark, but somebody else is cybersquatting on the corresponding domain name that I want. He doesn't have a legitimate interest to it. I have a legitimate interest to it because I own the federal United States trademark. But there's another prong, and it's a really, really, really important one, because a lot of people have domain names and maybe they're using it in a legitimate way, right? So sometimes I'll have a client come to me and say, well, I want that domain name. That person has it. It's mine. It deserves to be mine because I have the federal trademark. But when we go to look at the domain name, that entity is actually using it. And if they're using it in a legitimate way, meaning in a non-bad faith way, then it's possible that ICANN will not give it to you. Doesn't satisfy that doesn't satisfy the three prongs. And so what exactly is a legitimate interest and what exactly is considered bad faith is what I think Adam is what Adam can talk to. Not I think is what we want him to talk to. So we want you all to understand there's a lot kind of going on here. And I just kind of wanted to kind of set the stage for kind of what we're going to be talking about. Anyway, maybe we'll get back to this. Maybe we won't. Those slides, but I do want to introduce our speakers. Oh, and Adam already commented, which is great. So excellent. Adam, first of all, introduce yourself if you can. Everybody saw your bio where they actually registered, but if you can say a little bit about who you are, what you do, and then maybe later we can get into specifics.
Okay. Cut a long story short, I'm on the WIPO and Hong Kong International Arbitration Center domain name panels. And one point to elaborate on what David just said is ICANN doesn't actually do the dispute resolution. Basically, it licenses, I think it's 6 or 7 entities around the world, and you can file with any one of them, actually. So you could really pick and choose. Nobody actually bothers doing that. So I do two sets of them, if you like. WIPO is Elizabeth's defined it and that's based in Geneva. But it's not just WIPO, there's one in Prague as well. And a lot of the panelists are on multiple panels, so it's not not that much differentiation, in fact. Why don't we take a little bit of a look at the 3 branches quickly, which is I think what you want to start with. The first problem is, and it is important, is though David's advice to you, which is get yourself a registered trademark, is undoubtedly the right answer. It's actually not necessary to prove that you have a registered trademark for 2 reasons. One is that you can have what is called a trademark at common law, which basically means you'd win a passing off claim. Because you're so well known and your brand has tipped over the line from just being you to something bigger. So I got a case years ago at royjonesjr.com, jr.com. Fortunately, I know a bit about boxing. So when I saw it, I went immediately, first best pound for pound boxer in the world. And I remember that he had an involvement in rap music and clothes, a brand of clothes, which just about made it over the common law line. In the US law, there's a case called Centaur Communications. And by the way, their head office used to be about 100 yards from where I'm sitting in London at the moment. But they won a case in the Second Circuit on the meaning of a common law trademark right. So you do get common law trademark rights, the most famous and dodgy of which was Julia Roberts, the actress. I mean, quite honestly, she's an actress. That doesn't, yes, that makes it an unregistered trademark, but Julia Roberts never bothered to register her trademark, but the panelist, the WIPO panelist said, but she's terribly famous, that must give her common law rights. It's more fun with sportsmen like Mike Schmidt, who was found to have common law rights in his name, borderline. Anyway, so you can have common law rights. But the other thing is, and those of you who are in business will know this, often companies will have the trademarks held at one end of the business, just to keep it tidy. So you only have to have rights in the trademark. So if you have the right to use the trademark, even though it doesn't have to be an exclusive license, any sort of license, which typically comes from being a sister company to the trademark user, that's good enough. So you don't have that as a problem. The middle ground, the legitimate interest in the name, is actually a bit of a non-runner for both sides, both the claimant and the respondent, funnily enough, because everything really hinges on registered and used in bad faith. And note the word registered and, not or. So everybody has their favorite case that they did. My favorite case was MadameJojo's.com, which I did for the Hong Kong International Arbitration Center, which involves a transvestite nightclub, again about 10 minutes walk from where I am in central London. And in that case, to cut a very long story short, the real case actually wasn't very difficult to decide once the procedural mess had been cleaned up, because the biggest issue was, did the person who registered the domain name many years before the complaint was actually filed do so with a legitimate right, more or less, to do so? Now, what actually happened was that the owner of Madame Jojo's trademark argued that the license under which this lady ran the club did not allow her to register the domain name. But it's not a matter of legalities, it's a matter of good faith. If you're trying to run a nightclub, you're going to register a domain name. And so the moment she did so in 2003, that was pretty much the end of the case, actually. She could use it. If you look at it now, you'll find she diverts it to all kinds of weird things. But I'm afraid the way the third prong works deals with that. Now, everybody needs to be sensible, as David really was suggesting. I'm sort of expanding on what you said, more or less. There are plenty of people out there who go, I want to register a domain name. I've registered my trademark in this. Why am I being blocked? And the answer is because a company in Belgium has been trading under the same name for much longer than you have. And they may or may not have registered a trademark in that name, but they're in a different business. I did a case involving, I think they were in the stadium lighting business and bathrooms. It's a very different business. And there's no reason why there isn't room on the internet for both of you. But so don't get precious. You can't have monopoly rights over your trademark necessarily. Other people have the right to use it if they're doing it legitimately. One thing I would like to add to what David was saying was there have been several phases of cyber squatting. No, I'll shut up after that. It started off with, let's sort of blackmail people into paying us off. So Julia Roberts, I think, was a link to a hardcore porn site. When I went on the original WIPO training course in 2004, almost all the cases involved hardcore porn sites. I can honestly say I've been a panelist since 2005. I've never done one. I've done 166 cases, I think it is, when last checked. So that game is finished, that's left town. Now, what you're getting is domainers buying vast numbers of domains without any interest in using them and putting them on parking sites, waiting either to be bought out or alternatively just to trade them on and on and on. So in many cases, our concept of bad faith has changed. So if you hold something passively as a domainer, and there is somebody sitting there with a trademark registration that you really could have found out if you'd looked, then when you registered the domain name, then that will be regarded as being in bad faith, even though it's pretty passive. Just be a bit aware of the fact that and if you do have sites that are held in parking places, the registrars, I think it is, will put a background website in, which will look as though you're competing with your competitor, will have links to competitors of the name that's branded, which makes it look as though you're being far more wicked than you really are, in fact. And you shouldn't use that really as an argument. It's better just to say, come on, we all know that Gearhart Law is a name. It's probably trademarked, even if it isn't. If it is trademarked, David's mumbled, yes, it is, without his microphone on, then it's a sufficiently unusual name, Gearhart, that it's probably something you should have realized belonged to someone else. And by registering the domain name, you have almost certainly acted and it registered it. And then by hanging around doing nothing with it, you're using it in bad faith. On the other hand, if you just registered Gearhart Law and you're a motor car law firm, and you're James Hart, you can see why that might not have been registered in bad faith. That gives you an idea anyway. I'll shut up and let you raise questions with me as and when you want to.
Adam, just really quickly before we kind of let Paul introduce himself, and maybe you can kind of think about this as the time is going by. What is bad faith? I mean, that is, I think that is the hardest prong to prove these days. So can you give, like, if you can, you don't have to answer now, maybe.
Well, I can give you a short answer, and there's probably a very long one afterwards. The reality is, there's a general point. Those of you law students, you might be very interested in this. This is not a system geared in national law. So the notions of bad faith in national law do not apply. The only bit of national law, by the way, that does apply concerns whether you've got any rights in a trademark. And obviously it helps if you can find a legal system to which you can glue your rights. But beyond that, we don't have any notion of bad faith in any municipal legal system that you can lean on. So it becomes a thing that's developed case by case. There is, WIPO does issue a guideline, things that are obviously bad faith, typo squatting, so small typing error in the domain name, away from a well-known trademark would be one. That's a pretty classic example.
Yeah, let me put that up for people to see what is typo squatting so they can understand that. Hold on one second. I have a slide.
Well, Gearhart Law spelt Gearhart would be a good example of a typo squat.
Right. Here's some more like,
there it is.
Yeah, correct. The whole idea is that people are changing one letter to confuse the person that's trying to find them, and it's all about confusion from that perspective. Okay, yeah, that's a great example.
Yeah, and by and large, the first test, the confusing similarity, is sometimes called a gateway requirement. And basically, it's very difficult to fail there unless you have a problem with your trademark right. I've done a case with dangerous dogs where the complainant just failed to register a trademark, and the name wasn't distinctive enough and to get secondary rights, secondary meaning, I should say. I'm not an intellectual property lawyer, you probably tell, originally. And so she just never got past the first step. But typo squatting is one example, but there are many others. You get phishing, people doing fraudulent emails using a domain name. That's a pretty classic. You get counterfeiting. Sometimes you have domain names that are just in rather bad taste, and that becomes quite difficult because, it's not necessarily bad faith to not match up to your and my notions of what is acceptable on the internet. But I think I did one involving a particularly dodgy seniors dating website, which got a bit, whether or not that's quite in the stamp, whether that makes it to bad faith is a different question. But just remember that point, though, if you started off in good faith, subsequent behavior doesn't matter. You get a lot of these cases involving licensees of trademarks. So you're an exclusive dealership, you register the domain name, you get fired, you get terminated. You then switch the domain name to a link to your competitors, or something deeply disgusting. There's nothing to stop you. Now, one word of warning, actually, before I forget. ICANN, before lockdown, was talking very seriously about changing the policy to make it easier for respondents, not complainants. But there's no particular developments that I know of. Quite honestly, with these things, you wait till the final draft comes out. But I know there were discussions on that. So there's a watch this space banner out there.
Okay.
Did I answer your question? I mean, we've got this problem of passive fraud, of sitting on on domain names where somebody does clearly own the trademark and everyone knows it, and doing nothing with it has become bad faith, even if you don't really address your mind to it. So you might buy 100 domains, and you might lose 2. And it may seem a bit harsh to say you acted in bad faith when you probably didn't even know you had them. But you have a responsibility, if you're going to go around registering domain names, to realize that you are cutting somebody else's entitlement to reflect their name off in the internet. Although if you follow Victor's point, and he's right, the proliferation of GTLDs does give quite a lot of space for trademark names to be properly reflected in the internet anyway.
Yeah, and I actually have a bunch of questions about that for you shortly. But I wanted to, and thank you for that, Adam. We'll definitely come back to that. I want to get to our other panelist, Paul Laflamme, who's here with us. Paul has some slides that he is going to share. Paul, you can share your screen at any time, or did you want me to bring it up?
Great, thanks, David. No, I'll go ahead and share that. Just a comment to what Adam was saying. I remember early on in the internet, a teacher raised the concern about, and please don't try this right now, but whitehouse.com. Whitehouse.gov is a government White House site. Whitehouse.com, something completely different.
You know, everybody's doing it right now.
I know.
Paul,
I don't know what's there right now,
there is
but-
a fun answer to that question, which is that not very far from where I'm in London, there is a hotel called White House. And they almost certainly own the trademark and probably the domain name that goes with one version of it. So, so they would have probably a right to claim. There's also a state chain, I think, there was in the UK with that name. But often geographic identifiers can't be trademarks. I mean, to give you a quick example, you're talking, David, about the need for your trademark to be distinct. I actually own a trademark. I don't use it very much, which is the compliance factory. And the reason why it works is because factory and compliance are dissonant concepts. So compliance, making sure everything's compliant, and churning stuff out of a factory doesn't sound right. I will hand over.
Thanks, Adam.
Great. Let me go ahead and share this bigger here. Does everybody see that okay? Excellent. So I'd like to talk about some of the technical things you can do to protect your domain name from cyber squatters or ne'er-do-wells that might try to, get a hold of and create mischief for your business by doing something awful to your domain name. There's really 3 strategies I'm going to touch on. The first one is to lock down your domains, and I've got a slide to show you how you do that in GoDaddy, for example. The second strategy would be to increase your PC security overall. And then the third strategy that I think is important is just education. Educate yourself and your employees to be on the lookout for scams. Some of them are really, really crafty and very difficult to catch. So first, lock down your domains. When you register a domain name, you do it, and I'm going to show you GoDaddy just as a very common example. That's an international company where you can register with. But securing your domain name with a complex password. So your account should be secured so that no one can easily get in there and transfer the domain away. The other thing you can do besides a complex password is multi-factor authentication. You're probably used to that, say on Facebook. If you have a Facebook account, very advisable to secure that with multi-factor to avoid being hacked. And in banking, we often have to have a multi-factor. So a multi-factor, simply stated, would be some additional parameter that's used to identify you as the legitimate login person. So for example, it might send you a 6-digit code via text. It might send you the 6-digit code via email, or in the example I'm showing here, GoDaddy is looking for a 2-step verification to my authenticator account. So I have an app called Google Authenticator on my cell phone that pops up a code that I can then enter when I want to access my account. The auto renew and domain locking, very, very important that you set these on. Auto renew just keeps the ball rolling. Unless you consciously decide you're going to drop a domain name, you should really have auto renew turned on. Then if you get any kind of email about, oh, your domain's going to expire, you know that it's probably fake just because you know you have auto renew protection on. And then the other thing is domain locking. Domain locking down here, that prevents anyone from taking over your domain and moving it to some other registration site. When that domain lock is in place, it blocks the transfer away from your account. So very important. The third thing that I'm going to tell you can do to protect your domain name is registration privacy. So on the next slide here, This is a who is. So if you go to whois.com, and feel free to do this while I'm presenting here, because it's interesting if you've never done this on your own domain. But go to whois.com and just search your domain name. So I'm using my own as an example here, centrin.com. And you can see that the contact information you see on the right side here, that's what GoDaddy knows about me. That is my legitimate and real contact information behind the scenes. If ICANN needed to contact me via Adam's arbitration process, they would be able to provide that information to a legitimate requester. Anyone that would try to do something nasty with my domain name, however, is going to get this generic thing saying client transfer prohibited, register abuse at this address, register an organization. It's not even going to say who owns this domain, which is a powerful security. The second thing I would advise you to do to protect your domain name is to secure your computer and the network. Having strong antivirus software, having very dynamic and almost real-time security patch management is critical. You need to keep your system up to date. If you keep your system secure with these strategies I'm showing here, then someone can't get spyware into your computer that can hijack your credentials and thereby acquire your domain information that way. Maintaining an up-to-date firewall, uninstalling software you don't use. A lot of times, software that's installed, many people don't realize when software is installed, even if you're not using it, it puts its little hooks into your operating system. Those little hooks, if they're not updated because you don't use the software or run updates on it, can create vulnerabilities or expose vulnerabilities to your system. So my advice is to uninstall software that you don't use. And then as far as the firewall goes, your PC or Mac has a firewall, and that's okay if you're independent on your own PC or laptop. But if you're on a corporate network, you want to make sure you maintain the security code on the corporate firewall. The last strategy is education to avoid scams. I recommend security awareness training. Security awareness training, as I define it, is really just educating users on how to look at scams, how to be aware of something that's coming at you that really can look legitimate. Around the holidays, we often get things about, oh, your FedEx package is late. Well, who isn't sending or receiving a FedEx package or UPS package around the holidays, right? So it's really something that people fall for regularly, and they're very good at this. They make the UPS logo exactly right. Sometimes they'll show, like David showed on his cybersquatting typo screen, they'll do something to make it look like it's really ups.com, upss.com, who knows, ups-packages.com. There's a million things that they can do that as the recipient, we're all hurried, we're all busy, you're going to just breeze right over that. Then that's their hope, that you're not really going to be paying attention to it. Phone phishing is something else that happens. You'll get a phone call and they'll say, your domain's about to expire. If you want to make sure that doesn't happen, please go to our website or provide credit card details right now. And we laugh at it in hindsight, right? But people do fall for this. Believe me, they wouldn't waste their time doing it if they didn't hook enough people in with these types of scams. Now, on my last slide, I'm going to show you an email scam that you may receive about your domain. The email scam is just a solicitation, really, to try to get you to either give credit card information, transfer your domain to their control, or transfer your domain to another registrar at a higher price. Those are different levels of fraud, and I'll let our attorneys speak to how bad those different situations are. But if you take a look at a common email that you'll get, the highlighted words here are the giveaways to me. They state that it's a solicitation, right? They say you are under no obligation to pay the amount stated below unless you accept this proposal. Of course, otherwise in the proposal, it's saying that you're not renewing your domain. You could potentially lose your domain. So they try to do things here to probably protect themselves legally, but at the same time, a one-year domain registration does not cost $75. It costs between $7 and $35. So it's definitely something that they're trying to get away. They also add some legitimacy. New York, major US city, right? That's an important place. It's got some recognition. It's a way that they can give credibility to their scam email. And how we can help? Well, Centrin can help you with comprehensive security audits. We can help you figure out if your domain is secure, help you implement basically what I covered here. We can provide security awareness training. We can actually send emails out to your staff that will try to phish them. And if they get caught and fall for something, it'll provide training excerpts to little videos that are pretty entertaining, actually. They're 5 to 7 minutes long, and they kind of cover the topic of how that particular scam fools a lot of people, including yourself, and how you can be aware of it and protect yourself going forward.
Well, Paul, I need to say, like, and it's funny because here I am laughing about phishing scams, but I don't know if you remember this, folks who work at Gearhart Law, about 5 years ago, I thought you think you're never going to get caught by one of these scams. Like, you just don't think you are. And I got an email from, it looked as if it was coming from a court, like an actual court of law, saying that one of my clients had been served, for like, I don't even know, trademark, like patent infringement. Like, they really, like, you're sending to a patent lawyer the fact that one of my clients has been served in a court of law. I opened up that attachment and it just ripped through the firm within seconds.
Yep.
And now I'm a little bit better. But what I want to ask you is, like, where the F are the police here? I'm talking about, like, the internet police. Like, right. Who is, like, is it just Centrin that is acting as, like, the security border patrol, or is there something like is there something? Why isn't there something? And who can and who could you complain to if something like this happens?
You certainly can take action if you can figure out who the heck they are. If someone breaks into your home and you didn't lock the doors, well, yeah, it's not your fault, but you probably should have done a little bit more to secure your property, right? Same thing with what we're discussing here. And on this discussion here with you attorneys and myself, we're advising our clients to be diligent, to take the protection, to register the trademarks, to register the domain names, to lock the domain names down so that they can't be easily compromised. So there's no internet police per se, but if you can track down the culprit, yeah, there are actions you can take about that. I think the most important thing from my perspective is prevention. It's so much easier to prevent these problems than it is to address them. And as attorneys, I'm sure you tell your clients this all the time. Do the right thing, do it the right way, make sure your documentation is complete, and you're going to have a lot less cost and aggravation than trying to fight a lawsuit.
And so to that point, Adam, I'm curious, do you hear those types of cases too? Like, for instance, if somebody didn't auto renew their domain name, and then somebody snatched it, and then I guess took it away from the person that thought they owned it, and possibly locked it out of them. Is that something that kind of?
I haven't seen that one myself, to be honest with you. I have seen a lot of cases where domain names were clearly registered for the purposes of hacking into a company's, often quite big companies, mail systems, and often trying to get to customers of the company and tell them there's new bank details, they can pay them that way. I mean, a lot of these cases are, a lot of the domain name cases out there are not defended, and they're really pretty obvious. You only get the occasional dramatic moment, if you like. It's like flying an aeroplane. Most of it's sitting there and leaving the plane on autopilot. And then but the range of wicked behavior out there is fairly considerable. And as Paul rightly says, there isn't really much point in trying to take enforcement action. Remember, in a domain name case, Yes, it's nice and cheap to file. Is it $1,500? I think. The panelist gets 1,000 at WIPO and slightly less elsewhere. but the reality is that the panelist only has really two remedies, one of which is useless, which is well, actually three remedies, two of which are useless. Transfer of the domain name, which is the one you want, although you end up holding some, imagine you get typo squatted, you end up owning a lovely collection of domain names of misspellings of your name, which isn't a lot of fun. Cancellation, which doesn't stop anyone from registering immediately afterwards, exactly the same name. On the other side, by the way, we haven't spoken about this, is if you get too energetic in defending your domain name, the only remedy is finding of reverse domain name hijacking, which is meaningless, but is designed to tell the person that brought the complaint they really shouldn't have. The only risk there, and those of you who are lawyers or aspiring lawyers ought to bear in mind, I did get, I mentioned the Belgian company with its, I think they were in lighting and the other one was in bathroom manufacturing. And they wrote a cease and desist letter, and the Belgians wrote back in beautiful English saying, look, this is who we are, this is what we're about, go away. And I very nearly reported the law firm to the Californian bar, which would have been quite legitimate, because to file a complaint with any legal body, knowing full well that your complaint is useless, is in fact professional misconduct. Having said that, the finding of reverse domain name hijacking, as far as I know, which I've made once, that one case, I don't think actually has any real meaning. But yeah, a lot of these cases, people are quite clear what they're doing. They're buying a domain name to commit fraud in some shape or form. And when you ask David about what's bad faith, quite a lot of the things you might call loosely offenses of dishonesty, shall we call them, are immediately bad faith. Like, if you sell knockoff handbags and stuff in your domain name, it's pretty obvious that's why you registered the domain name. That's a pretty good classic example of bad faith, even though the registration itself is not inherently bad faith. The purpose to which you're using it is. There is, by the way, a more complicated one, which is where people register a domain name and then offer it for sale. Now, the policy, which David flashed up a summary of on his screen, gives examples of what is bad faith, and famously offering for sale a domain name at more than the administrative costs of registration is evidence of bad faith. But quite frankly, if you register a Wendy share, if you like, that's not, there's a two-name, Wendy's a common first name, share as an activity. And then after a while, you realize it's really not that interesting. So you offer it for sale to the rest of the world for a decent sum of money, but well over the level of what it would actually cost. Is that really bad faith? It's a good question, actually. Oh, you've got my Julia Roberts, but usually these are cases that's one of the Julia Roberts cases, I think. But I'm not sure. I believe, by the way, that Julia Roberts had any sort of right to her trademark. But that's my view.
I kind of want to ask Adam and Paul a question. It's a very common advice that we sometimes gives to clients that come in, assuming they've, hopefully filed for their trademark, or, at least from our perspective, that's something they should do. Common law rights are great, but they can be kind of limiting. But usually we say to them, well, why don't you right now, as you're starting your business, buy up all the domain names, right? And this kind of goes to Victor's point. Like, there's .com, there's .biz, there's .info, there's .net. Like everybody's like, just .com, I'm just gonna buy the .com. But really, I'm curious what the two of you think in terms of kind of protecting your property and potentially protecting a scam of buying them all up yourself, and kind of, and just buying all the kind of all the extensions and possibly some misspelled words. Do you think that's a good strategy?
No, because it's very expensive, and maintaining your pile of domains. I think we have to learn not to be too precious in this world. If you've got a trademark, I mean, I own this compliance factory. There is actually out there a recruitment agency on my patch, my sort of area of activity, which I could actually ask to remove their website, their domain name. I choose not to. A, I don't use the trademark that much, and B, because I think being too precious doesn't help the world very much. I mean, there's a barrister called Adam Samuel and an actor called Adam Samuel. I own adamsamuel.com and .co.uk. I am more than delighted to allow the others to own their share of the internet, because I've got my brand out there. I don't really need a total monopoly, and I don't think I could administer it. I mean, some of those of you who are inventors, and it might take a different view, whether you've got the capability to knock everybody else out of the space, or indeed the need to.
Yeah, I totally agree with what Adam just said. And I want to add to that, when you're starting a business, I do encourage you to register as quickly as possible, like as quickly as you found that it's available and are considering it. I encourage you to register that name, because Adam, I'm not sure how this works on the back end, but I know for a fact that there are cyber squatters that are able to get lists of domain names that people have considered. And what they'll do is they'll buy that on speculation that you're going to decide you want that and will pay a premium for it. Well, it's not going to work if it's centrend.edu or .biz maybe, but if it's itsupport.com that I was considering, that how could I say that I have the right to that any more than anyone else? It's a great name that would be very valuable to a provider. So that's what's happening, is you have a great idea and you look at considering different domain names, and then you go to actually register it, and someone has already grabbed it because on speculation that you're going to pay them a premium for it.
Yeah, but I think you just have to be a bit real about what you're prepared to invest in this area. I've got an interesting question from Ashley. The concept of a trademark, first of all, you're going to have to help me a bit, but when you talk about the supplemental register, if it is by law, Ashley, tell us what you mean by that. That will help everybody else as well.
Yeah, maybe you can explain the question, Ashley. That would be great.
Yeah, of course. So under the third prong, I know we indicated the domain name has to be both registered and used in bad faith. Yep. So my question's regarding the registration. I know when we talk about federal registration, in the US, there's a principal register where the mark has distinctiveness and it's really geared towards the owner of the good. And then there's a supplemental register where people can register their trademark on there where it has not yet acquired that additional distinctiveness. And over time, you can move the trademark from the supplemental register, hopefully to the principal register.
It's a trademark, is the short answer, Ashley. Okay. I think I can give you a quick, I thought that was the answer. I just wanted to check I understood correctly. If, again, there is a view that, by the way, that even the concept of trademark should be supranational. It shouldn't be based on US law or anybody else's. The idea is that as a complaint, first of all, it's a surface and entry requirement to the process that you can show that you own some sort of trade rights in a trademark that is confusingly similar to. So it's only supposed to be a front door because the cases are supposed to hinge on bad faith. That's the idea. So any sort of anything that could be called a trademark legally is one. Is the short answer to your question. And the point is that you could have a situation, Ashley, where bizarrely you decide that you wish to register your trademark in Belize, country with which I assume you have no connection. I only said that because my Pilates teacher comes from there. But the point is that gets you, if Spurbeck is your trademark, it's an interesting name, that gets you through the front door. Now you've got to prove that it's confusingly similar. Well, if I've registered Spurbex.com, you've probably passed that. Then the question arises, why did I register it?
Got it.
And if the answer to that question is, I registered it because I bought my uncle's business and he was Mr. Asper Beck, his name was Asper Beck Esquire, then you've got your answer. Indeed, by the way, increasingly, I mentioned the point earlier a little bit, but when you bring domain name cases, people are very careful, good consultants are very careful not to go after the borderline ones. You know, you don't have a go at somebody being reasonable. I mean, I have an argument, you can all have a lovely time if you look around the Compliance Factory. I think there is compliancefactory.com. But hopefully, I mean, the answer to Jean-Marie's excellent question.
Yeah, it's a great one. It's a good one.
It's an impossible one to answer as well. It's very clearly explained, so well done. But the reality is, it depends how important it is to your business. Yeah. So Victor, you're an inventor. Your name is probably rather more important to you, your trademark, than it is to me, than mine is to me. I don't know.
Maybe. Again, it's not necessarily my own name, Victor Urbach. It's more of my entities that I create.
Yes, that's what I would expect rather than your name itself, yeah. Whereas in my business, my name is me, more or less. And so I actually don't have my name trademarked. I choose not to because I reckon I've got the 2 domain names I want. And the rest, and I can always defend a case because I've been running my own business in my own name for 30 odd years. And Elizabeth knows me, which is probably.
You know, I kind of want to, I want to just make a comment to your question, Jean-Marie, because I think it's a good one. I want to give you like a little story. I have a client named Wasteless. And for many, many, many years, they could not get wasteless.com. They had every other domain name that you could possibly get. And the company that owned wasteless.com was a Canadian company that was using it in the right way. And so it took and so we approached them, we asked them, we thought maybe we would file a UDRP and try to just throw, S at the wind and see if it would stick. That in of itself cost them $3,000. It didn't go anywhere. We knew it wasn't going to go anywhere. We thought maybe that the Canadian company would not fight it and then potentially we might win it. It didn't work, as Adam agrees, and we kind of knew it wasn't going to work. And then eventually we reached out to them and we offered them, $10,000 for it. And some people would say $10,000. What? Like, I'm never going to pay $10,000 for something that I could potentially spend $3,000 to file a UDRP or possibly get it for like $399 when it's up for renewal or something like that. But this really meant a lot to this company. They wanted the .com. So to answer your question, it was their business decision that they were going to pay $10,000. I definitely know companies that will pay the ransom that Adam was talking about. If the price is $20,000, $30,000, $50,000, if it's worth it to that company, they will pay it. And that is usually against my advice as a lawyer that says, you are paying a ransom, right? This should not be. This is not how it's supposed to be. But I think to answer your question, I think you need to determine how much is too much, right?
I would disagree with you, David, because I don't think it's a ransom. It's not terrorism either.
But Adam, that's what I learned today. But Adam, that's what I learned today. Clearly, it is a legitimate business for someone to catch a domain name first and then sell it. But that's not really how the system was supposed to be created. That's why I trying to stick to my law.
Yeah, but hold on, David. I mean, you know perfectly well the risk of lowering the tone somewhat. That sex.com was the most expensive domain name ever registered because everybody wanted to get their hands on it because of the hardcore porn industry. And you know, this business that was legitimately registering the domain name and was legitimately running a business using that name had an asset that your client wanted and that it was worth your client paying. I mean, MadameJojo's.com is a really interesting one from that point of view, because at some point that club will reopen, and it's a fantastic name for various historic reasons in the Soho area of London. And quite honestly, I don't understand myself why the very wealthy owners of the club don't sit down with the lady that registered the domain name and do a deal. She's got something they want. It's a perfectly respectable asset. She registered it in good faith. She ran the club in good faith very effectively for many years. She has something they want. It's a price.
Paul, any comments on this?
Actually, a question for Adam about that. So if suppose I sold my company, Centrend.com, well, Centrend is my company, would the buyer have to be aware or beware that I would be selling Centrend.com along with the assets of the business? Is it assumed? I mean, I would, as a buyer, assume that I'm getting the domain name and the website along with the other assets that I'm acquiring. But is that something we have to be careful of?
I think so. I think you have to make sure that when you do this is taking us outside our area in effect, but this is my commercial lawyer hat going on, not very steadily, that when you buy a business, you buy it, you make sure that you don't leave anything behind.
So where it comes back to your realm, Adam, would be if it wasn't stipulated in the purchase and sale, the sale went through without that stipulation, and then the seller cybersquat saying, well, if you want that domain name, it wasn't part of the purchase and sale, you're going to have to pay me another exorbitant amount of money to get it.
Yeah, because you've got the problem that the registration, when it originally happened, was registered by the vendor company in good faith and was traded in good faith for many years before the sale. So you can have problems in that space. I think when you buy a company, you've got to make sure that you buy the whole company and not half of it. If you're going to use the name, you may buy the company and then rebrand it. And if you rebrand it, then of course the old domain name is irrelevant.
Yeah,
you know,
that's true.
Yeah, I have definitely drafted like website and domain name agreements. Like that's like a separate asset that needs.
It's interesting. Yeah.
Yeah, for sure.
Anybody?
Adam, please, Adam, go for it. Go for it.
Well, I was just going to give an example that my great-great-grandfather, Philip Blaschke, was the silversmith that designed the trophy for which the Australian states still play cricket. He designed it in the 1890s, but somebody bought the business who's not related to me at all. And if you look up philipblaschke.com, I think it is, you'll find the website, and it describes it as if it was my family. There's nothing wrong with that. They bought the business. They also bought the domain name, or they actually probably registered the domain name after they bought it. But you get the idea that it's a transference of rights, which is fine.
Yeah.
Value.
By the way, if anybody has any questions, just you can either speak it out loud or chat it, and you can ask it.
Yes, I have a question. Sorry, I'm late.
Yes, you joined us a little late. What's up?
What are the most important tidbits that I miss in 2 or 3 words? I don't want to take too many.
Bob, we actually recorded it and we can send it to you afterwards.
We'll have a go.
Sounds good.
But go for it. Adam can sum it up for sure.
I think we should summarize things good. Register your trademark properly. That was the point David made to begin with. Accept that other people will have registered rights to names out on the internet. So you don't have exclusive rights. So you do need to pay attention and register the domain names you actually want and need promptly and quickly. It's relatively easy to bring domain name disputes, but just remember that if you're going to try and bring a claim against another domain name holder, this is David's Canada company example, you've got to prove that they both registered and used it in bad faith. So if they registered it in good faith, it's also Paul's question, I think, then that's not going to get you very far. The domain name procedure is designed to pick up people who behave badly on the internet and people who buy chunks of domain names without looking to see whether they infringe people's trademarks. It's not designed to pick up legitimate competition, people using names reasonably reputably within limits. That would be my summary. And you don't have to own the trademark to bring a domain name case. You just have to have rights in the trademark, which could be because you have a license to use the trademark that allows you to bring the claim. And also that remedies are limited to transfer and cancellation of the domain name. You don't get anything else through the ICANN system.
Paul, did you want to give us a summary?
Oh, you go for yours.
Yeah,
Sure.
yeah, that's good. So it makes sense for someone, like, for example, wants to start up a website to go through the entire process of them buying the domain name and everything, even if they're going to test the concept to see if it has traction. Does it make sense to go through the entire motions to buy and everything registered?
Registering a domain name is not very expensive, which is probably a good reason to do it. Is that
okay.
reasonable, Paul?
No, I mean, I'm just asking.
Yeah, I think so. If you're going to start a business and an internet presence is going to be important, and the name in question is going to be important, then it makes very good sense to do it. So in my case, although I don't have a registered trademark in Adam Samuel, as soon as the internet got going, I registered adamsamuel.com, put a website on it. Because I'm in the UK, I picked up co.uk just to protect myself a little bit. And then I discovered whether it worked. So yes. You can always let them let your registration lapse after 1 year if you only register it for a year. So
and Bob, we had another speaker who can provide a quick summary as well. That was a good one. You missed that one too. But you have it.
Sure, I'd be glad to summarize
Thank you.
that in just a few words here. My advice was, from a technical standpoint, is to use the tools that are available on your registrar to lock down the domain so that it can't easily be hijacked or transferred to another provider, and make sure that your domain is private as well. And then on your IT side of the house, where your computer and network is concerned, make sure you have as much security in place as reasonably possible so that you can avoid any kind of compromise to your system where they could obtain your credentials and hijack your domain.
Excellent. Just a few more minutes left. Adam, we've been talking a lot about the actual proceeding that you are an arbitrator for. Can you just take us through it, like the timeline? The cost is basically, there's an official fee, there's probably a legal fee, but more I'm talking about like, the cost, the actual process, the timelines. How quickly does this happen?
Okay. Well, the first things first, it depends a great deal, by the way, on the registrars, because they often hold these things up. But let's start at the beginning. If you think you've got a problem and you file your complaint with, say, WIPO, is a good example. They've got a set form. They've got a lot of guidance about how to do it. So you just follow it. A few words about how to file a complaint, actually. Please don't try and sound like too much of a lawyer, strangely. You've got the 3 tests that you've seen on the screen. Well, all the best lawyers, I think, are very good at not sounding like lawyers in general. It's a good form of lawyering. But just follow the thing through. Don't make every point imaginable. Don't tell the panel how fantastically well known you are, because you've either got the rights or you haven't, and just shouting at me and telling me, which if I'm reading it, that you are incredibly well known doesn't really get me very far, because you might be a wonderful person, a wonderful business, but I may never have heard of you. So stick to the facts. Register trademark. This is the evidence. Brief 2-liner about what we are up to, and perhaps a link to our main website. That's good. So don't overcook it. The shorter ones are the better ones. They're often bizarrely filed in English by people whose first language is not English, because you keep your language short if it's not your language. So keep it tight, keep it short, keep it clear, Don't accuse people of things they didn't do, and you know it. Anyway, the cases are filed. The centres, and they all work the same way, have to get confirmation from the registrars of stuff. And there's often a delay caused by privacy services, which nowadays get uncovered typically. So you end up amending your complaint, which is a bit tedious, by changing the name round to get the right name. You don't amend the rest of it, but it takes a bit more time. There is then a period in which the respondent gets a chance to reply. And as I said, vast majority don't reply. The case then lands on the panelist's desk. You should be able to do them in under 24 hours most of the time. You get occasional slow ones, and they take a month or two if you're unlucky. But I mean, I probably took longer on Madame Jojo's than I probably should have done, but it was, if you ever read the decision, and I'll happily make it available to you because it's available, published on the internet. I had so much fun doing it. I possibly had a bit of a party with it. There are a whole range of other issues I haven't mentioned about the case so far. So, but it really should be done pretty quickly. Then you're in the hands a bit of how efficient the centre is in processing it. Centres like fiddling with panelist decisions. You get as a panelist, you get them back with typically, you know, the odd punctuation mistake picked up, but also some of their magic formula they want you to use if possible. Always remember that there is, you know, there are these guidelines. WIPO has a guide to the 3 requirements, which you can easily follow through. But it should be really quick. It shouldn't take a month. It really shouldn't. But you are in the hands of that registrar, because the registrar doesn't answer the request for confirmation that they've got the domain name. You can be taking a while. The other, by the way, one word of warning, which I hope doesn't apply to your clients, please don't register with a service where the registration agreement is in other than their first language. There was a spate of registrars that operated in Korean, and you end up having domain name proceedings in Korean, which, unless the parties agreed not to have it in Korean, does not cause problems. But really, it should be very, very pacey. You do occasionally, I mean, my royjonesjr.com, if you're going to claim common law rights, please provide the evidence for it. The attorney for Roy Jr., Roy Jones Jr., you can see it on the decision, basically said, my client has common law rights, full stop. They didn't say he was a boxer, I don't think, let alone the boxer. And as a panelist, I was left in the classic "Who's the Rolling Stones" position. It's a well-known English judicial joke, you know, about the judge who made a complete idiot of himself by saying, "And who are the Rolling Stones?" To which the answer was a well-known beat combo. It's a 1960s court case, but you, as a panelist, you want to avoid being thought to be totally stupid. So I very carefully issued a procedural order saying the panelist is aware of a boxer called Roy Jones Jr. Could the attorney for the complainant please provide evidence that his client is indeed that individual, and also that he has an evidence to support his claim of secondary meaning in his name. And the lawyer got very cross with the centre about it. Said it's bloody obvious. To which the answer was, yes, it was. But, you know, if you are going to run a common law argument, you really ought to provide some evidence for it. But mainly it's about keep the complaint short and succinct.
Okay. And beginning to end, you get a decision when?
Well, as I said, you could get a decision. I've forgotten what the time lag is from, I can pull up the rules, which tell you how long the respondent has to reply, because that's really the question. I think it's not very long. You've got a couple of weeks, I think. Like I could be hopelessly wrong about that. I'm busy desperately looking to find it. I think it's like
45 days or something, 45 to 60 days, something like that.
I don't think it's that long, is it?
Oh, it feels long.
GDRP rules, I think is what I want.
Okay, while you're looking for that, any other questions before we kind of say some final words? Questions, comments, concerns?
Good session.
Oh, good. I'm glad, Wendy. I'm glad you enjoyed it. Okay, Paul, any last kind of best practices that you can give us or give everybody?
You know, I think we've covered it well. The idea of being able to keep your domain renewed and active all the time is important. ICANN has some great rules in place, though, that try to help. So, for example, if your domain does expire, you might not realize it. You go to your website's down, your email's not working, things like that. Well, ICANN will not allow someone else to register that expired domain for a certain period of time. Is it 30 or 60? I forget which end, Adam. I think it's 30.
It's not my territory, that one.
Yeah. I think it's at least 30 days. And then prior to the expiration, you're not allowed to transfer the registration to another registrar for 30 days prior to that. So there's some safeguards that have been put in to try to help. But again, what we said earlier, I think is key. You know, you got to keep it registered, keep it locked, keep your systems as secure as possible.
It's 20 days to issue a response, to reply. Just run, you can look at that document. I just pulled it up quickly. So you can imagine, so if you issue your complaint, if you're going to really switched on registrar, you know, you could be, you know, that could happen in 24 hours. It sometimes does. So the complaint goes off, 20 days to reply, no reply received. Then the center typically approaches someone, and if they're reasonably switched on, they can say, yep, you could have a decision 2 days later. Really, it could be that fast. Sometimes the centers are a bit slow, and lockdown hasn't helped, you know, with pandemic, because they found it difficult to be as efficient as they once were. But that's also affected registrars. But the real problem is the registrar delay, which is very unmanageable.
Okay. Any other final thoughts, Adam, before we kind of break? Best practices, anything?
Just remember not to be, as I think the biggest message for particularly the law students in the room is, yes, you're learning some law, but it doesn't mean you have to flash it all over the place. Is this the real answer? When you look at in fact, it's a good way to practice being a lawyer. People like Helen and Ashley. Well, Ashley already is the real thing. Helen is, you're studying, aren't you? Is to file a domain name case for someone, just as a bit of fun. And just see if you could slot your details in without using 9 million words. I think most of the cases I do could have been, most of the complaints could be half the length.
Okay, great. We got some really good nuggets from both of you. We're very excited about that. Thank you so much. There's some, if you want, I guess if people want your PowerPoint, Paul, can they reach out to you directly as well?
Sure. Yeah, I'd be glad to send it.
Okay, same here. If you want the recording or anything like that, let us know. Next month, we are doing another entrepreneurial strategy series. I think the date is March 24th at 12 p.m. Eastern, and it's all about the do's and don'ts of prototyping. And so we got great panel of speakers. Please join us. Look out for our email invite, and talk to you all soon. Have a good rest of the day. Thank you so much, Adam. Thank you, Paul, so much. It was great. Thank you.
Pleasure.
Take care, everyone. Bye-bye.